Today I am going to try and demystify a few issues which we as transgender healthcare providers face. Well, the biggest issue that we face is that what is the medical legal standing? And this arises primarily because the reading of the Transgender Persons Protections of Right Act and the interpretation that we have of the Transgender Persons Protection of Rights rules. Yes, the Act came out in 2019 and was based on the Nalsa judgment which came out in 2014. Nalsa judgment talked about gender being a self-affirmed process. That means I, as an individual, affirm the gender that I possess. And for this, I do not require validation from anybody. By the time the Act came out, there were certain things which got added on to this due to the understanding of the Nalsa judgment by the cis-hetero majority and their perception of what can probably go wrong if we allow the Nalsa judgment, that means the right of self-affirmation, to be exercised by individuals. And after a lot of deliberation, this Act came out in 2019 and it said that yes, gender is self-affirmed. Happiness, everybody was very happy with that. But then it went on to talk about transgender as an umbrella term, which included people who had differences in sexual development, what are commonly known as intersex people. This came from a space where the lawmakers had very poor understanding of the gender experience and thought that maybe anybody who has ambiguous genitalia would also fall under this bracket, and they included them. They further included sects like the Hijra and the Kinnar and the Jogtas to also be part of the transgender umbrella. And the thought process was that these are all marginalized communities and they all need a little hand holding to be done. When they went on to explain as to how gender identity would get reflected in the documents, the Act started talking about the need for a medical certification, wherein it also went on to say that this certification would be given only after certain interventions have been done. Now this led to a lot of turmoil in the community, and the community was very rightly upset that what was given to them in the Nalsa judgment in 2014, the right for self-affirmation, was being denied by this Act, which exposed them to medical examination and the need for medical certifications to be given for them to be changing the identity markers in their documents. All these issues were debated and were brought to the notice of the would-be authorities who had the power to do something about it. And good sense prevailed. The rules which came out later, that is in 2020, addressed this issue of gender being self-affirmed. It also, to a certain degree, addressed this issue where the community felt that they would need to be examined by somebody else to validate what they were affirming, by stating that there is no need for any medical examination to be done. And the rules categorically said that for your gender identity documentation to be done, and if you want a transgender identity to be written in the documents, then all you need to do is to self-affirm your gender, get a affidavit, attach your address proof, and submit this whole thing online to the district magistrate, who would record all this, verify, and issue you a transgender identity certificate within 30 days of the application. No need for any medical examination, intervention, no opinions needed. Purely self-affirmed process. It went on to say that, however, if you want to be known as male or female in the gender in the documents, in that case, you need a medical certificate by the institution wherein you have undergone any gender affirming medical intervention. And this gender affirming medical intervention may be opinion by a mental health professional, maybe a clinical psychologist. You may have undergone hormone intervention, or you may have undergone surgical intervention, however not necessary. And this is what is different from the Act. This is something which we as medical providers need to know. We also need to understand that why was this need for a medical certification put in place? What is the thought process that the cis hetero person who was designing these acts and rules thinking? Well, we give benefit of doubt and say that this is probably so that the individual comes under medical care. Medical care not because the person has got a pathology, but because the interventions that are needed are available with the medical providers. Also, this would give a sense of security to the person, because once this process is done by the government, done online, then there is less chance of dysphoria. Another thing that happens is that anybody who gets this, goes through this process, would also get benefit of the schemes that the government has put out to them. And they have very rightly linked all these schemes to the transgender identity declared by the individual. This is something which we as providers need to know, because this gives us that medical legal security. The moment I have anybody who's registered on the portal walking into my clinic asking for gender affirmative interventions, my issues that I have, whether this person is committed, is this person going to take responsibility for what interventions are going to happen, does he understand the bigger picture? All these are more or less addressed, because anybody who has filed this application, who has gone and got the affidavit from the magistrate and has uploaded all the documents, asked for a change in gender identity to happen in their legal documents, shows that this person is by and large committed. It also gives me a lot of a feeling of comfort that I am not going to get penalized. This person tomorrow cannot turn around and say that, I was confused, because we have the transgender identity which has already been done by him. This also helps us in guiding that individual towards the schemes that are there which would make transgender healthcare more accessible and affordable. And yes, that is also a very important role which we need to play as healthcare providers to ensure that care is given to the individual which is accessible and affordable. Whenever we have any person who's diverse and approaches us for gender affirming interventions, we again use this act and rules as a tool for education, as a tool to empower that individual, because this not only talks about gender identity, but it also conveys to the individual what are the rights that that individual has. What is the healthcare sector going to provide and how? What is the Ministry of Social Justice going to do about it? And hence, when we understand the act and the rules correctly, when we don't appear confused to the individual, then we build trust with this individual. And we leave the choice to the individual as to what degree of affirmative care they want and where do they want it from. And that's a very important empowering feeling to be giving to the person who's walked into your clinic looking for gender affirmation. That yes, you are the person who's going to decide, because gender affirmation is done by you in accordance to NALSA, in accordance to the Act that has come out in 2019, in accordance to the rules that have followed in 2020. And yes, it would be a good idea to come under gender affirmative care. This care may start by the mental health provider who counsels you and who walks you through what gender affirmative interventions will do, and also tell you what they will not do. It gives you that feeling of being in control and not being shifted from one binary to the other because the provider feels so. Hence, it is important that each one of us read the Act, understand the rules, and understand the intent behind what is written. I would also like to bring out a very important issue. What do we write in the medical certificate? Especially now that WHO says gender incongruence is not a mental health issue. The Indian Standards of Care also support this. The Standards of Care version 8, which is going to be put out by WPATH, also talk about this. So what do we write as providers of transgender healthcare? We take this opportunity to highlight the importance of providing care as a team. Hence, the certificate that we should be issuing should be done by the person who is the leader of the team, the leader of the gender affirmative care team. And it should just state that the individual in question who is asking for this document, this is their affirmed gender, and this should state that this individual has undergone a gender affirming procedure. If you wish, you can further qualify as to what is the nature of the gender affirmative intervention that has been done. However, to my mind, if the leader of the gender affirmative care team is signing this document, then that is not a requirement. But we can say that the individual has undergone gender affirmative intervention in the form of mental health counseling or endocrine intervention, or has undergone gender affirmative surgical intervention. Remember that this certificate that you are providing is a medical legal certificate, and all that that is asked from you is to validate that the individual is under medical care. They are not asking you what exact procedure did this individual undergo. That, you must remember, is confidential information. That is information which is rightfully owned by the individual and not yours to dispense. Hence, you are on very firm legal ground by stating what this certificate is needed for. This certificate is just needed to confirm to the district magistrate that the individual who wants an identity of male or female to be put in the legal documents has undergone a gender affirmative intervention. The rule, it comes under the heading of gender affirmative medical intervention, and that is enough for certification. I would also like to highlight that the discussion so far is regarding medical certificate which has to be issued for change in identity markers in the documents. This certificate is very different from the letters of recommendation which are issued by mental health professionals, not necessarily psychiatrists. Even clinical psychologists are well qualified to issue letters of recommendation. The purpose of the letter of recommendation is to progress further in gender affirmative care. For progressing on to gender affirmative medical interventions such as hormonal interventions or gender affirmative surgical interventions, these letters need to be detailed. The team needs to be comfortable that the individual has understood what are the pros and cons of the interventions that are going to be undertaken henceforth. And the mental health provider needs to give this assurance to the team members that they are there to sort of do hand holding if so required. Hence, these letters of recommendation are more detailed. However, the medical certificate, which is for change of gender identity markers, is given by the leader of the gender affirmative care team of the institution wherein the individual is undergoing gender affirmative medical interventions. And these need not have too many details. The purpose of these two are different, and we should always keep this in mind. I hope I have been able to demystify the medical legal position, the Transgender Persons Protection of Rights Act, the Transgender Persons Protection of Rights rules, the medical certificate which is to be issued for gender identity markers to be changed in documents, and I've also clarified the fine difference between this medical certificate and the letters of recommendation which are issued. Thank you for your time.